some examples that we've had to deal with in our office that can maybe just give some insight to some of the issues that I've covered in that objection and appeal process. So here, this taxpayer approached us. We didn't do financials, but they approached us because they had various final letters of demand from SARS, and all they were initially looking for was for deferred payment terms. They were, in their minds, in agreement with the assessments raised. But we did really what Computex accountants should have done and interrogated the underlying basis of those assessments. And these companies in the group were charging admin fees between each other for the provision of staff. And that should be a neutral transaction, but one of the companies was an educational institution, and therefore it was exempt from VAT, and therefore if it was charged an admin fee, there was leakage in the system, and that gave rise to the financial imbalance and the liability to SARS. And when we were looking through the documents, we saw some other demands, some demands for PAYE. And we saw that there were 3 companies registered for PAYE, not just this one management company. And it transpired that the management company actually only employed 2 out of the 49 people. The rest were all employed by the underlying companies themselves. And as such, there should not have been a management fee charged. It was really a recovery of the salaries that were due and payable by those underlying companies themselves. And so the whole VAT issue dropped from an issue of 49 staff being charged out to only 2 staff that were being charged out. And that was quite a significant change. It's making quite a bit of feedback. Just because one looked at the underlying reason of the assessment, albeit that the assessment was what the taxpayer had lodged themselves. Now, we spoke a bit at the beginning about SARS's onus to show... Joe, this is bad. I'm not doing anything different. To show that an estimated amount is a reasonable amount in determining such an assessment. So here SARS looked at an input reconciliation, reconciling the input VAT to the expenses claimed by the taxpayer, and focused on one particular year. And in doing so, they failed to take into account that the rules for VAT are different to the rules for income tax. You need a valid tax invoice in order to claim the VAT input, but you might have accruals or provisions in an income tax determination that will be different from the VAT. So we said, well, is it reasonable to look at 1 year? Or is it not more reasonable to look at 4 years? And a 4-year review would show a difference of some 250,000 Rand between the VAT and the income tax, and not the 6-odd million that was highlighted in 1 year. SARS determined they could not meet their onus and abandoned the matter at the letter of findings. That's why it's very important to try and knock out as much as you can at the letter of findings. They will come with their 10 issues at findings. If you knock them all out, it ends there. If you knock half of them out, they don't go back and audit for more. They just deal with the half that have not been dealt with fully to their satisfaction. And you limit what you need to deal with in the formalistic objection and appeal process. Now, this is a matter, the various sections in the Tax Administration Act and the rules relating to objection and appeal, the current rules as they stand now. I'll make some comments with regards to the new rules, and I'm just going to highlight certain aspects in the legislation that are important for us to give consideration to, and it will tie in with what I've said before. I didn't give the legislative basis. Now you'll see the legislative basis for what has been given to date. So we now have a whole lot of different types of assessments. We previously just had assessments, and then by nuance you called them original or revised or reduced or estimated, but they now are all separately defined. 91, that's the legal basis for SARS to raise an original assessment, but that's not key to our issues. 92 is really where our objection and appeal process starts from, an additional assessment raised by SARS following an audit to correct an assessment, and that is the starting point where we will then begin our objection process. Reduced assessments are an important addition to the process. When one talks about the button on e-filing, request for correction, in essence, its legislative framework is the reduced assessment. 93(1)(d), SARS is satisfied that there's an error in the assessment as a result of an undisputed error by SARS, where they left out a deduction that should have been claimed and was put on the return, or an undisputed error by the taxpayer, where they put an amount in a wrong section, or put half or double or whatever an amount, but an undisputed error. So that is the legislative framework for the request for a correction. Generally, my view is that the request for corrections, one must be careful with them. They are there only where there are undisputed errors, and if you then have a dispute later as to the error, then it's more difficult to get into the objection phase. This is, please sir, will you give gracious consideration to fixing my return, and I can't do anything if you won't. The objection has teeth, and you can take the process through because you have made an error in my return and I want you to fix it now. It's a very different approach between the two. But the nice thing about this is it does allow us to go in beyond the time frames as long as we can show it's an undisputed error. So Computech could come now, 3 court cases later, and make an application for reduced assessment because there's been an error by SARS that is undisputed because they took the group and not the company, and if you put it out very clearly, it's an undisputed error. That is one of their remedies for the position. But if it's something where there might be a dispute as to whether you're entitled to a deduction or not, or entitled to an allowance or not, it's risky to do this. You'd rather first try to do the objection route as long as you're still within the 3-year period and can show some sort of an exceptional case. But if you're outside of the 3-year period, this is an avenue to apply for reduced assessment as long as you can show, and you'll have to be very careful in showing it's an undisputed error. Can be either by the taxpayer in not claiming something or by SARS in not allowing something that's picked up late outside of the 3-year period or outside of the period when there is an exceptional circumstance. But at least there is some avenue. But this is not formalistic by way of objection. This would be a request through the branch manager for them to reduce the assessment in terms of this. Sometimes the e-filing button stays open indefinitely, sometimes it closes at the 3-year period, but we are of the opinion that this is not time barred. Jeopardy assessments, these are things that we are not going to reach very often. That's when the rich and famous are boarding their private jet and the SARS official taps on their shoulder and says, sorry, please will you pay this assessment through your computer now before you board your jet, or come with me and we've got better lodging for you. So we're not going to get this very often in our practices, but at least we know that such a thing does exist. The estimated assessments, that's something that you will generally cause to happen because your records have been destroyed, fire and brimstone has happened, and you can reconstruct to the best of your ability, but you won't sustain an audit. You come to an agreement with SARS by way of an estimated, in the old jargon, an agreed assessment. So for instance, it happens to many employees, they have their pay slips, but the employer absconds, hasn't paid the PAYE, won't give them IRP5 certificates, but they can can go and agree an assessment with SARS on the strength of the pay slips, and SARS allows the PAYE. That is the process that you go through. You can object if SARS doesn't process what you agreed, but you can't at a later stage suddenly say, look, we agreed R1 million taxable income, but I've now reconstructed my documentation, it's actually 500,000. No, you're bound at the R1 million because that's what you agreed at the time. Now, notices of assessments. A notice of assessments doesn't only have to be that pinky purple IT-34. It can be a letter, as long as it sets out the name of the taxpayer, the reference number, the date, the amounts, the period, the date when you must make payment, and how you can deal with lodging an objection. That can all be done by way of a letter and not the pinky purpley form. And that is part of the reasons why the process date is the key date, because that is the date that the physical letter would have been uploaded on e-filing, and that's the same date that the IT-34 will be processed. The two dates are linked. But even if they're not linked, if you have a letter that's called a letter of objection, our courts have ruled that this is a valid a letter of assessment. The courts have ruled that this is a valid assessment, and then the dates and the timing start clicking on from the date of that letter of assessment. It meets all the necessary criteria, and in fact it gives you a lot more information generally than the IT-30 form. SARS has to record all of the assessments. The fact that they can't print out an assessment again, they can merely give you a screen print, it doesn't change that too dramatically. SARS can now withdraw an assessment. So in the days of the film scheme, they tried to withdraw assessments that they'd issued and then changed their mind and issued a nil assessment to withdraw it. And when they later came to issue a new assessment, the taxpayer took the prescription defense, and SARS were barred in that they had not withdrawn because there's no ability to withdraw an assessment. Now they can withdraw an assessment, so it is as if that original assessment never was, and the next assessment that they issue will be an original assessment and not an additional assessment. So there's a process for them to withdraw. It's also useful for us. We can also request SARS to withdraw an assessment issued on an incorrect taxpayer in respect of an incorrect tax period. So once again, Computech, 3 court cases later, can make an application in terms of 98 for withdrawal of the assessments on the basis that they were issued on the incorrect taxpayer, the group, and not the correct taxpayer, the company. And so they also will not be time barred in terms of this application, not through the normal objection process, but through an application to the branch manager. But at least there is an avenue both for SARS to withdraw and for the taxpayer to request a withdrawal of the assessment. Now, prescription, various sections on prescription. It's now in section 99 of the Tax Administration Act, but the key issue to highlight is 99(2)(a), the fraud, misrepresentation and non-disclosure of material facts. That is still the defense against prescription, and the old case law is then still applicable, and one mustn't forget one's rights in that regard. If you don't deal with the objection on a time-yes basis, if you don't deal with the appeal on a time-yes basis, if it's been through the process, those assessments are then final. Your only possible remedy is an application for a reduced or a withdrawn assessment, but I wouldn't put too much reliance on those. Those are hopes and prayers and not rights. So in general, if we are late in dealing with matters, we get to a finality position, and then our rights to take the matter forward have terminated. Burden of proof. So that's the legislative framework for the burden of proof. And key in that is 1022, the burden of proving whether an estimate under Section 95 is reasonable, or the facts upon which SARS based the imposition of an understatement penalty is upon SARS. They have the burden of proof on those two key aspects, and those generally will be the two fighting grounds that we will have. The understatement penalty is a material matter that we're all going to deal with, and the estimated assessments when they try to do reconciliations from the IT49, the SD, and the VAT returns and all that relate to that, those are also estimates, and the reasonableness of those estimates will be another fighting ground that we will have. We've got a lot of issues where we have the burden of proof. That's the legislative framework for that. Now, Section 103 of the Tax Administration Act is where the new rules will ultimately come through. But at the moment we are still using the rules under 107A of the old Income Tax Act. Those rules are still valid, and those rules still find their way through to our day-to-day activity. But the new rules in their draft form will ultimately be promulgated in terms of this section. Section 104, that's the legislative basis for us lodging an objection, and the additional 21 days if a senior SARS official is satisfied, and thereafter the exceptional reasons, that comes through from the section and is reinforced in the rules. A number of the seminars deal with the issue of taking SARS on review in the High Court and or taking matters to the tax court. Section 105 of the Tax Administration Act, that's the legislative framework which allows us to take certain matters on review and certain matters through the tax court process. That's beyond our scope as accountants, but at least we need to know that those legislative frameworks exist. Yes, another question.
There was the court case, the Overseas Trust Corporation, where they went directly to the High Court. And then the High Court said, what are you doing here? Because this is a matter of fact and circumstance.
Yes.
Not a matter of law. And basically costs were then attributed back to the taxpayer. The taxpayer had to pay council's costs. So it's quite an expensive experience.
Yes, the question was, when one takes a matter to the High Court, one needs to be careful essentially that that is the forum and not the tax court, which will deal with matters of facts as opposed to matters of law and matters of review. Absolutely. That, as I said, that's outside of our scope. It's a matter where the attorneys and the advocates are going to have to give the clear guidance. We just need to know that there are avenues at times where one can break the deadlock of going through the tax court, which is a longer process, with urgent applications for review. For instance, at times when there is no decision or an adverse decision on the granting of the suspension of payment pending the objection, that would be an administrative decision that one would take on review. It won't be for us to formulate that. We just need to know that these things exist so that we can advise our clients that they then need to seek other professional advice other than us from a legal person in that regard. Now, SARS has given us a decision on the objection, and that comes through from Section 106, and there are some time frames when they must do it, but more importantly, they must give the basis for the decision and a summary of the procedures for appeal. Once again, these are hard-fought issues that they must give us the reasons for the notice of disallowance, not just your objection has been disallowed, full stop, moving along. They need to give us the reasons so that we can draft the appeal accordingly. There are still some, however, that get this wrong. These would be issues that you would need to raise through the professional bodies to try to make sure that the inherent processes are correct. Now, the appeal, that comes through Section 107, that's the legislative basis for the appeal, and the 21 days with the reasonable grounds, and the 45 days for exceptional circumstances. That comes through in the Act and to some extent in the rules as well. And the appeal must meet the criteria, and that's where the ADR2 form and the NOA form come in to make sure that we meet the necessary criteria applicable. SARS has to either concede on the appeal and decide that some matters must go to the tax court or the tax board. They can concede in part, and still others can be then subject to the dispute process. Most times they don't do this at the appeal stage, they only do this at the ADR stage.